Okay, thank you very much for having a look at this slide. My name's Nikki Daniels. I'm from the Service Development team, and I'm going to be taking you through the changes that were made to the Immigration and Asylum Category Specification, and that went live or goes live on the 1st of April. So in this training, we're going to have a look at the national referral mechanism and the new bolt-on fee that has been brought into scope. We're going to move on to looking at priority removal notices and the new work that's being brought in there. We'll then move on to looking through the controlled legal representation changes that have been made, and then we'll also finish with the work on Group 2 preliminary decisions, so the differentiation work that you may have seen in the Nationality and Borders Act. Okay, so we're going to start with the national referral mechanism. So as with a lot of the changes that we'll be talking about today, this will go live from the 1st of April 2023. Okay, and this is bringing work into scope that wasn't beforehand. So this will be advice on entering into the national referral mechanism. If you're not sure what the national referral mechanism is, if you go down to slide 20, all the links for the important web pages are on there for you, and you can double check. Okay, so the National Referral Mechanism advice, as I say, it's advice on entering into the NRM and is not ongoing advice, and it's also not standalone advice. So this is work that needs to be done in addition to one of your existing matters. So it's for an existing client only, okay? Now, there are some matters that aren't in scope for this and some matters that are. So the matters that are in scope for this work relate to Part 25, 26, 27 and 27A of LASPO. So that's all your detention and immigration bail related advice. It will also be Part 30, which is your immigration rights to enter and remain. It's Part 31A, so that's your immigration, citizenship, nationality work for separated migrant children, and also Part 19, which will be judicial reviews. Now, just bear in mind that that is only immigration related judicial reviews that are going to meet the conditions as set out in that part of LASPO. So make sure you do double check that. Okay, if you have a look in your slide pack at slide 6, you'll see that this is advice that can be done either as procedural advice. So that is things like, what is the NRM? What does it do? How do you get referred into it? Things like that. Or it can be more individualized advice, okay, and that means it could be what is the impact on that particular client of entering into the NRM. Okay, so have a look at slide 6 and it will go into detail on there for you. Okay, we also do have the contract amendments on slide 7, so please do have a look at those. But also, again, if you go to slide 20, you will see that the links to the specification, you can find that there. Please do go and double check the contract documents themselves. Okay. It's important to recognise that this bolt-on NRM advice, it does not include ongoing advice for the client once they have been referred into the national referral mechanism. Okay, and you should also be aware that if you have the same client, say at legal help stage and then at controlled legal representation stage, for example, and you offer them the advice and you give that advice at the legal help stage, you wouldn't then be able to give them similar or the same advice and make another claim at the controlled legal representation stage. So it is one fee per client rather than one fee per matter. Okay. Also, just to bear in mind, this is a bolt-on fee, so it isn't going to be part of the escape fee calculation, okay? And it also should not be included in that profit cost calculation either. So if you are claiming this for a matter that is paid hourly rates, please do make sure that that is not part of that profit cost calculation that you do, okay? It is part of that bolt-on which will be paid separately. Okay, and as we're talking about claiming, if you move on to slide 8, you will see that we have put a couple of screenshots into those slides for you so you can see exactly what's happened. So this bolt-on fee should hopefully be nice and easy for you to claim. So it is £150, and you should see on the right hand side of that page, about halfway down, there's a highlighted drop down field that has been added. All you need to do is make sure that you select yes in that drop down field if you have provided the advice. If you haven't provided the advice, you just need to select no. Okay, we'll move on to priority removal notices. Again, this is something that is coming into scope and is going live on the 1st of April 2023. So this is a new piece of advice that is non-means tested, and it is also paid at hourly rates. Okay, and this advice can be provided to a client that presents to you with a priority removal notice that is issued by the Home Office. If a client comes to you with one of those notices, as I say, it is non-means tested advice, and that non-means tested advice lasts for up to 7 hours. Okay, so that is 7 hours of non-means tested advice in relation to their immigration or asylum status. That's 7 hours of non-means tested advice that cannot be extended. So that is a hard cap. So unfortunately, that cannot be extended beyond that 7 hours. Okay. However, follow-on work is also paid at hourly rates. So once you have determined that there is a substantive matter as a result of this PRN, and that is either an in-scope matter or a matter that is funded by exceptional case funding, okay, you need to move that client on to that substantive matter as quickly as possible. Okay, you won't lose out. As I say, both are paid at hourly rates, and also to make this even easier for you as well, what we have made sure is that ECF application, whereas normally you would do that at risk, and if it was approved, then you would get it paid for after it had been approved. That will be part of that 7 hours. So if you identify that the client doesn't have an in-scope matter, but they would be eligible for ECF funding, then you can make that application and that will be paid for as part of that 7 hours of advice. Okay, as I say, that 7 hours is not extendable. So if you do see a client who doesn't have a substantive matter, whether that is in scope or out of scope and can be funded by ECF, that limit cannot be extended, but you can still give them that full 7 hours non-means tested advice regardless. Okay, so if you realise after, say, hour 1 or hour 2 that they don't have a matter, you can still take them right to the end of that 7 hours. Okay. As I said, and we've put it on slide 10 there, so it's really easy for you to find, that follow-on work is any immigration or asylum matter that is opened as a result of the initial PRN advice. So that is in or out of scope matters, and that out of scope, you just need to make sure that you get that application in for ECF funding as soon as possible, and that will be paid for as part of those 7 hours. And again, just to reiterate, the follow-on work as well as that initial up to 7 hours of non-means tested advice, it is all paid at hourly rates. So you will not lose out by making sure that you get that client onto a substantive matter as quickly as possible. Okay. As I say, the initial PRN matter, it is capped at 7 hours, so you won't be able to claim profit costs above that 7 hours. There is a disbursement limit, and that is the usual £400 that is in place for asylum matters. That is for the initial claim. Any follow-on matter will have the cost and the disbursement limit that is appropriate to the type of work being conducted. So that will depend on whether it's an immigration matter, an asylum matter, if it's legal help, or if it will be controlled legal representation. Okay, so you just need to double check exactly what those limits are. That is all in the specification. So as I say, all the links are down there at slide 20, and you can take a look at the specification. If you've got any questions, if you're not sure, you can always contact your contract manager as well. Okay, now this is a new piece of work, so slide 12 will just set out exactly how you make a claim for this work. It does come in 2 parts, so there is that initial claim. As I say, hourly rates, so it is paid using the code IAXL, so that's your matter type 1 code, IAXL. Okay, and the matter type 2 code you should be using for this work is IPRN. So that is the code combination you're looking for when you're claiming for up to those 7 hours. Okay, just make sure that you are recording how many hours of work you are doing. Okay, and it is a maximum of 7 for that initial claim, if you remember that. Okay, on that slide 12, you will see that we have added another drop down. Okay, so there is a new drop down that is called follow-on work, and you'll be able to see that there are a couple of options there. So for example, you've got CLR, you've got legal help, you've got JR work, you've got licensed work, and you've got non-applicable on there. So when you are making that initial claim for that up to 7 hours, what we ask you to do is just to fill in that drop down box. So select the most appropriate answer to that question. So what follow-on work have you done? Okay, or what follow-on work are you intending to do? So what is the next step that you're going to be taking, and just select the most appropriate one from that drop down. Okay, if there is no follow-on work, so again, that 7 hours is capped. If there's no substantive matter that you'll be taking that client forward with, then you must select the non-applicable option. Now, for all other matters, so anything where you are not using that code combination IAXL, IPRN, you will still need to complete that drop down. Otherwise, you'll get an error message. You won't be able to complete the claim. But for everything else, so unless you are looking at the MT1 code, MT2 code combination of IAXL, IPRN, you must be selecting non-applicable. Okay, really important that you select non-applicable, and then your claims will go through. Again, if you're claiming up to that 7 hours, you need to choose which is the most appropriate. Okay. If you are conducting any follow-on work that is going to be paid through CWA, you need to make sure that you are selecting the most appropriate MT1 and MT2 codes for that follow-on work. So as per usual, you need to have a look and just double check that the codes are correct. Again, any questions you have, please feel free to contact your contract manager, but do take a look at the CWA guidance first. That does list all of those codes for you. And again, it is on slide 20. The link is there for you, so you can double check. Okay. That follow-on work, if it does fall under licensed work, just keep in mind as well, also paid at hourly rates. So it doesn't matter if it's controlled or licensed work, it will be paid at hourly rates if it is follow-on work from an initial priority removal notice. Okay, we'll move swiftly on then to controlled legal representation. As I'm sure you are aware, controlled legal representation has been with us for time immemorial. This is not bringing something into scope. However, we have introduced some new fee changes into the contract from the 1st of April, and there are also a couple of changes to the way that work is going to be paid in relation to legal help. So the key date date here is going to be the 1st of April. Okay, 1st of April 2023. So whereas previously, if a matter was subject to the standard fee scheme, so that is fee 2A, 2B or 2C, or those interim hourly rates that were introduced in 2020, if your CLR matter has a grant date of the 1st of April 2023 or after, okay, those matters will all now be subject to the new fees that have been introduced. Okay, so that is the 2D or 2E standard fee scheme rates that have been introduced. Again, the key date is the grant date, so it's the 1st of April 2023. Any matter that is subject to the standard fee scheme or would have previously been subject to the interim hourly rates, if it is granted 1st of April or after, you will only be able to select the 2D and 2E rates. Those 2A, 2B, 2C and interim hourly rates will no longer be possible if the grant date for CLR is the 1st of April 2023 or after. Okay, it's really important as well that you now understand that the legal help and the controlled legal representation matters, they are now two completely separate matters. So whereas before they would be claimed and they may escape together, you would use a double dash when you're claiming that legal help because it was a stage claim. That is no longer the case. So that legal help and the CLR matters are now completely separate. Okay, so the legal help will need to be claimed as a completed claim when it is finished, and then the CLR will also be a completed claim when it is finished, and they will escape completely independently of each other. Okay. Now, what we have done is we have introduced a new lower escape fee threshold of 2 times the standard fee, and that is for any case with a start date or in relation to controlled legal representation, the grant date, which will be recorded as the start date, okay, of the 1st of April 2023 or after. Okay, now we are aware that this does mean that we will, for a long period of time, have some legal help matters with a start date of before the 1st of April, and then we'll have a CLR matter with a start date of after the 1st of April. So they will be able to escape at different thresholds. So anything that has a start date, a grant date of the 31st of March or before, that will be on the 3 times the standard fees, the standard fee threshold. So that is what is in place now. Okay, anything with a grant date or a start date of the 1st of April 2023, and you're going to get fed up of hearing that that date, but anything with that date or afterwards, okay, that will have that newer, lower threshold of 2 times the standard fee. Okay, as I said, really important, okay, that the CLR case start date, that is when the CLR was granted. Okay, we want to make sure that as many people as possible can take advantage of those lower 2 times the standard fee threshold where it is applicable. So please make sure, whereas before your CLR and your legal help had the same start date, that is no longer the case. So the CLR start date must be when the CLR was granted, okay, from the 1st of April and afterwards. Okay, so let's take a look at slide 16 and we'll have a look at how we can claim those CLR rates. Okay, so as I said, if it is a matter, so a CLR matter that would have previously been subject to those standard fee scheme rates, so 2A, 2B, 2C, or the interim hourly rates that were applied in 2020, okay, then your standard fee scheme, the only options that you have from the 1st of April onwards will be that 2D or 2E matters. Okay, so 2D or 2E will be the only options where you have a CLR matter that is subject to the standard fee scheme. Just to be really clear, any matter that is one of the exceptions that is listed in the Immigration and Asylum Specification as being paid at hourly rates, the new CLR fees they're not applicable. They are hourly rates. They do not change. Okay, we're only talking about matters, CLR matters, that are subject to the standard fee scheme. Okay, now we have got 4, as has been the case with the previous ones. So if you're claiming for an asylum matter with no hearing, you need to use the matter type 1 code IACE. If you're claiming for an asylum matter with a hearing, you need to claim with the matter type 1 code IACF. If you're claiming for an immigration matter with no hearing, you might have got this one already, it is going to be IMCE. And if it's an immigration matter with a hearing, it will be IMCF. The matter type 2 code, as ever, should be whatever is most appropriate to the matter that you are claiming for. So again, double check those CWA guidelines and just have a look and make sure that you're using the most appropriate one. Okay, as I have said before, so the legal help matter should now be submitted as a completed claim. So it shouldn't be a stage claim with that / outcome code. Okay, it must be submitted as a completed claim. Okay, and where that legal help is moving on to CLR, okay, you need to make sure that the outcome code is recorded as IE. Again, that has been put into that CWA guidance, so you can double check there if you need to. Okay. And as I've said, the CLR start date, that needs to be recorded separate from the legal help. So it's no longer the same as the legal help start date. And the CLR start date will come from the date that the CLR was granted. Okay, so that grant date needs to be recorded as the CLR start date. And remember, the key date in all of this is the 1st of April 2023. So that's when all of these changes come in. Okay, right, let's have a final little section for us. So if we all move to slide 18. Okay, we are going to look at the Group 2 refugee decisions. So this is known as differentiation as part of the Nationality and Borders Act. It has been in the specification for quite some time now. So it was introduced in July last year in 2022. And there have been these decisions, these preliminary decisions have been being sent out by the Home Office. Okay, so some of you may already have seen these. For some people, it may be completely new. Okay, but what this this differentiation advice allows is it brings into scope providers being able to advise clients following receipt of a Group 2 refugee preliminary decision. So if a client comes to you, they already have an asylum case, and as part of that asylum case, they are presented with one of these Group 2 refugee preliminary decision letters. Okay, what you need to do, you need to keep the existing matter open. That's really important. Okay, and then to deal with this Group 2 preliminary decision, okay, you need to open a separate matter, and in that separate matter you're going to deal with advising the client on what it means, so what that Group 2 refugee decision would mean for them and for their matter. Okay, and you'd also need to, if you were instructed to draft the rebuttal document to go back to the Home Office. Okay, now that is new work that has been brought into scope, and it has been brought into scope at hourly rates. So you are going to get paid hourly rates for this work. Okay, so you're going to use the matter type 1 code IAXL. It is part of the asylum claim. So it is an IAXL matter type 1. And we've introduced a new matter type 2 code, so IDIF. Hopefully that will be quite easy to remember. But again, it is all on those CWA guidelines, so you can double check in there. Okay. So you need to make sure that work on that preliminary decision rebuttal, that is all claimed hourly rates separate from the asylum claim. Okay, separate from the asylum claim. Once that rebuttal work is completed, you close that matter, and any subsequent advice needs to be done on that existing asylum claim. Now, as an exception, what will be happening with regards to these matters and means testing is slightly different to how it works in other matters. So due to the connected nature of this rebuttal work with the initial asylum claim, so they are completely connected, and also with regards to the timelines that the Home Office have asked for these to be worked within. Okay, if the client, if you have an existing client and they have advised that there have been no changes to their circumstances which would impact their eligibility for legal aid, okay, you do not need to get a new CW1 form. You do not need to redo that means testing, okay, even where the evidence for that initial means test is more than 6 months old. What you do need to do is you need to make sure that a copy of the original CW1 form is retained on the file of the preliminary decision. So the Group 2 rebuttal work file needs to be on there. You also need to make sure that there is a copy of the evidence that was used for that means test is on that Group 2 refugee preliminary decision file. And you also need to make a note on that new file of the asylum claim UFN, okay, so that we can see if that file is looked at, we can see what the link is. And as I say, as long as the client has confirmed that there are no changes to their circumstances since that original CW1 form was signed and the means test was completed, you don't need to redo that means test or get a new CW1 form signed, okay. Okay, but if a client tells you that they have changed their circumstances, so if anything has changed and they advise you of that, okay, what you need to do is you need to apply the guidance that is in section 11 of the Lord Chancellor's guidance. That will help you to determine if a reassessment is required on the open asylum matter. If a reassessment is required on the open asylum matter, then you must do that reassessment, okay, and whatever the outcome of that original asylum matter, that will be applied to this rebuttal work, okay. If a reassessment is not required though, so you've double checked that guidance in section 11 of the Lord Chancellor's guidance, you've determined that no reassessment is required, in that case, nothing needs to be done. As you did before, what you need to do is make sure that a copy of the relevant CW1 form, okay, and copies of the means evidence are retained on that rebuttal matter file, and a note made of the UFN of that linked asylum claim. So exactly the same as it was before, but you must make sure that you have applied that section 11 of the Lord Chancellor's guidance to determine whether reassessment is needed. Okay, really important on that one. Okay, as I said, this work is claimed at hourly rates. I've given you the code, so the matter type 1 code is IAXL and the matter type 2 code is IDIF. Okay, and as with all of the things that I have discussed today, if you do have any follow-up questions, if you're not sure, if you do want to check anything, please do have a quick look at the question and answer document that is also available. So where you found this webinar, you'll also be able to find that question and answer document. And if that doesn't work, please do go and speak to your contract manager and they will be able to advise you further. Thank you very much for your time and have a good day.